Was the Attorney General under George W. Bush, his first Attorney General, and really led the way on the administration's domestic response to the war on terror after 9/11. Prior to that time, he had been a senator for the state of Missouri. He was a controversial pick for Attorney General because of his strong conservative religious views, and there was some pushback, but he was confirmed as Attorney General. Initially, he seemed kind of bored in the position, but then came 9/11, and everything changed. The Attorney General's role is a really fascinating one. It was one of the very first cabinet positions created. It was number 4. It was a part-time position, unlike the Secretary of State and the Secretary of War and the Secretary of Treasury. And the Attorney General, in fact, initially didn't even live in D.C. But as the federal government grew and federal law increased, the Attorney General then had to be on hand because it was his job to argue cases before the U.S. Supreme Court. And there weren't very many in those early years, but eventually it became an extremely important role. It really expanded with the modern presidency and Franklin Roosevelt, because as the federal government grew and federal law increased in more areas, it was the Attorney General's mandate to oversee it. The Justice Department was created in the wake of the Civil War because a lot of lawsuits and legal actions relating to the Civil War erupted. And initially, private attorneys were hired by the government. It was very expensive. So they brought in, and they created then a Department of Justice and eventually a Solicitor General who took over the role of arguing cases before the Supreme Court. It's now a very large bureaucracy, and the Attorney General is at the head of that. The Attorney General also plays an important role in most administrations, providing legal advice to the President. Of course, there's a White House counsel who is more directly tied to the presidency, but the Attorney General is supposed to be looking overall at the entire government system and what kind of cases should be brought before the Supreme Court and where are the big issues. Legal policy making then is often there in the Justice Department. Reviews of judicial nominees is in the Justice Department. And what I find really fascinating about the Office of Attorney General, it sits at the nexus of law and politics. So here you have someone who serves in an elected administration, assisting the president in that constitutional duty to take care that the laws are faithfully executed, and at the same time is the chief law officer of the nation.
This just in, you are looking at obviously a very disturbing live shot there. That is the World Trade Center, and we have unconfirmed reports this morning that a plane has crashed into one of the towers of the World Trade Center.
9/11 had a pivotal effect on the development of the Office of the Attorney General, certainly during the George W. Bush administration. We haven't yet seen that the ripple effects are continuing in that office with future presidents, but we do know 9/11 transformed much of the Justice Department's mandate into being much more proactive, much more aggressive, and that's because of the nature of the strikes. They were in the United States. It was a domestic attack. The government decided, President Bush, the day of, decided to frame it, the nation's response, as a war, that it was a wartime attack on the United States. It wasn't a crime. It wasn't even an international human rights violation. It was or an international crime. It was a war, and that required a different domestic response than we have seen ever before. Prior to this time, wars have been something that have happened internationally, other than, of course, the Civil War. So here we had a war where the shopping malls could be the battlefield. You know, it was even articulated that way by John Ashcroft. You know, no place is safe in America. Further, our rights and liberties were used as weapons against us. So he understood the attack as being the exploitation of freedom of movement, of freedom of speech, of religious liberty, of the press. Therefore, those things had to be more closely monitored. It wasn't that civil liberties would be damaged just in the course of war, which has happened before. You've had restrictions on liberty in every previous war, but you can return to some normalcy after the war. Here we had a war that was where the vulnerabilities were the rights and freedoms. And as a consequence of that, there were a lot of attacks on civil liberties coming out of that.
Our war on terror begins with Al-Qaeda, but it does not end there. It will not end until every terrorist group of global reach has been found, stopped, and defeated. How will we fight and win this war? We will direct every resource at our command, every means of diplomacy, every tool of intelligence, every instrument of law enforcement, every financial influence, and every necessary weapon of war to the disruption and to the defeat of the global terror network.
By framing it as a war on terror, not just the Justice Department, but the entire government was opening up an enormous range of power for the executive branch. There would be no limits on who you would go after. It wasn't even a war on al-Qaeda or a war on the Taliban, much less a war on a nation state like Afghanistan or the Soviet Union or even an ideology like communism. It wasn't even a war on Islamic fundamentalism. It's a war on terrorism, and terrorism is a tactic that's been used for thousands of years. It's not neatly defined, so you can never really win, right? A war on terror, it's never going to be over. And Dick Cheney, as vice president, made a point of that this could be a limitless war. It's not bound by geography, it's not bound by time, it's bound it's bound really by nothing. It's bound by whenever the United States decides it doesn't want to be at war on terror any longer. And when government is in the business of fighting a war on terror, there really aren't going to be the kind of limits. Attorney General Ashcroft then saying things like, the government is not limited because to limit the government is to make the government vulnerable. If we're transparent as a government, if the Freedom of Information Act is used so that the press and non-profit actors can get access to government documents, that endangers the United States. So he shifted the presumption of the Freedom of Information Act to non-disclosure rather than to disclosure. Government transparency suddenly became a vulnerability for the government, so they wouldn't share information even with committees in Congress, or when you would get documents, they'd be heavily redacted. It made it much more difficult then for the U.S. Congress to engage in one of its constitutional functions, which is oversight of government programs. How do you know if a program is working or not, if a law ought to be changed? The members of Congress, the House and the Senate, have to have access to that information. Even if it's only a small group of them, seeing things in camera, in secrecy, so that there's not a problem of exposure to the wider world. The executive branch didn't even want to do that. The executive branch argued multiple times that the courts had no role in reviewing immigration cases or certain types of cases, enemy combatant cases, that was beyond the purview of the Justice Department. What does that mean? A major impact on separation of powers. The Patriot Act was the measure that really empowered American law enforcement to proceed with a lot of aggression against anyone seen as a terrorist threat, but it was drafted in a way that gave law enforcement authority over even ordinary crimes. Or if you were caught up, you weren't, say, the focus of an investigation, but you were tangentially related to it, then your bank records and library records might also be sucked up in the data sweeps that the federal government was now going to be doing. You didn't have to be the terror suspect to suddenly find your information being caught up. There's also a section of the Patriot Act that was used by the National Security Agency to get access to all the phone calls that Americans made to internationally. And when Edward Snowden, a whistleblower in the National Security Agency, made clear this enormous scope and how many ordinary Americans' calls and electronic data had been swept up in this, the government Congress reacted very strongly, and in 2015 passed, I think it's called the USA Freedom Act, to reassert some control on that level of NSA spying on ordinary American digital footprints. So it's an extremely powerful piece of legislation. Much of it is not especially controversial at all. But there are provisions within the Patriot Act that have been very troubling to civil libertarians because they do empower government to act in a way to gather information that is otherwise private without something like either a Fourth Amendment due process, Fourth Amendment warrant issued by a judicial magistrate, issued by a judge, or even a reasonable suspicion that a crime has occurred or is about to occur, or that there's the crime of planning, of complicity, that you need to get access to the documents. You don't have that. It's just almost like an open-ended, forever search warrant in general to anybody. So there has been some scale back in 2015 by Congress. John Ashcroft fully believed that revealing information of any sort in how the government promulgated the war on terror would increase the likelihood of an attack, would make the United States very vulnerable in the context of this larger war. Therefore, information was very, very tightly held within the executive branch and not shared, say, even with co-equal branches. Certainly not shared with the newspapers, the press, and definitely not shared with the American people at large. So many of these changes are made without Americans knowing about it, without any discussion. So when you had this big trade-off between security and liberty, which many countries go through and debate on and try to decide where do we find the balance here, we never had that discussion in the United States because we didn't really understand, certainly for the first several years after 9/11, when these measures were at their height, we didn't really know how much our liberties were being limited, how constrained we were, really what information on us was being gathered by the government. I think there's a really key lesson here, and that is that the system of checks and balances require maintenance. We can't just assume that they're always going to operate when one of the branches acts in a tyrannous manner or with a very broad claims of power. That we have to ensure that the constitutional system is actually operating as it should. When I was young and the Watergate was coming up when I was in college, I was a young journalism major and very fired up by the role of the Washington Post and the importance of journalists, right, in exposing wrongdoing, and the hearings, the Watergate hearings, how important those were for exposing wrongdoing, and the role of the Supreme Court in the U.S. versus Nixon case. And I took that as a young woman as evidence that, see, checks and balances work. This is the sort of thing in many countries that could have led to autocracy. But we had to check. All these elements of government are working together, and the civil society, the non-governmental actors like the free press, this is what the framers meant. This is how it all is supposed to work. I think what was troubling for me after 9/11 and continues to be an issue for me in how government operates is we can't take those checks and the checks and balances for granted. We have to be aware as citizens. We have to be ensuring that voices on the other side are heard, that very, very broad and unparalleled claims of power are checked, that there's mechanisms operating throughout civil society and in government and state governments. Federalism is another thing that we need to make sure that all of these elements are in place for the government that the framers created in the Constitution actually works. And that's, I think, the takeaway for me. We have to be engaged in midterm elections. We have to be engaged in state and local elections. We have to inform ourselves. There's no reason to go into a polling place and look at a ballot and not know half the answers. You need to think about this in advance. There's a duty we have as citizens. We have freedom, we have a duty. And I think the duty side has gotten kind of downplayed, so we just sort of defer to these other actors. They'll take care of it. They'll make sure things are taken care of. We blast the media. We blast the members of Congress. Well, how about us? I mean, ultimately, we're the ones responsible for ensuring that democracy works and that the checks and balances are vibrant and that they're actually operating as the framers intended.